witness, his name was Ebenezer, who testified that when this crowd came up, they were taunting the soldiers and tormenting them. They had sticks, but they were hitting the soldiers were standing there with their muskets before them, holding them out before them in a somewhat defensive position, and they were hitting the muskets with their sticks as they passed in front of the soldiers, taunting them to shoot, shoot. They knew that the soldiers were under orders not to shoot unless they had an order from the civilian authority. Now, I expect when Judge Holdsworth instructs you as to the law, that if the soldiers believed they had to use deadly force to defend themselves, to protect themselves from the use of deadly force, they had a right to do so. And that's going to be the issue for you. That's the question for you. Did these soldiers fire in self-defense? Or did they fire as part of their response to just being taunted and their hatred of the people of the city of Boston, which they've displayed and which you've heard testimony about? That's the issue for you, is did they fire in self-defense or not? And the way for you to look at this is examine the evidence before you. Examine what the behavior was that's described of those individuals. Examine their motive for going out there in the first place, why they went out there, and what other actions they could have taken. If the only action that they could have taken was to defend themselves, then you should come back and find each one of these defendants not guilty. If, on the other hand, you believe that the use of deadly force was not justified under the law, that the circumstances that they were confronted with it was unreasonable for them to use deadly force. They had muskets, they had bayonets, they could protect themselves. If their job was to protect the custom house, which maybe it was, maybe it wasn't, that's a little unclear, they certainly could have done that with the weapons that they had before them. There was no evidence other than some snow and ice being thrown. There was no evidence of the nature of those. There was some evidence that there were some rocks thrown. There was no evidence as to the force that was used, the distance from which the objects were thrown, whether or not they really hit anybody. The only evidence we have of anybody being hit was Captain Preston's description, who said something hit the soldier to his, I forget whether he said his right or left, you'll remember it when you talk about it, and that soldier stepped to the side and then fired a shot. If that's what happened, if this was a response to taunting, that's murder. That wasn't self-defense. And the other soldiers had to fire. Now they're all, don't forget this too, these are other facts. And talk about these facts. You'll remember the testimony a lot better than Attorney Adams or I will give it to you right now, because you'll have an opportunity to think it over. You sat there and you paid attention. Talk in detail about the testimony and refresh each other's recollections about it. But you'll remember some things, I think, when you do go over the details. Among those other things that you'll remember is the exact details of what happened, the order in which they happened, and what was going on at the time those shots were fired.
Excuse me, 2 minutes.
2 minutes? Thank you, Your Honor. I'm about done anyway. They're all... The people of Boston are relying on you, and these defendants are relying on you to come to the right verdict here, to consider the facts, consider the law, weigh that testimony carefully. You've taken an oath to come back with the verdict that's fair and just under the law. Judge Holdsworth will instruct you as to what that law is. It'll be fairly clear, I believe, and you can follow that. Deliberate as to the facts, think it over, and the Crown would submit to you that if you really evaluate the evidence closely, you'll find that these soldiers acted in a concerted effort to shoot the townspeople they shot. And the result was 5 were dead, 6 were wounded. 11 people were shot under circumstances where they certainly didn't have to be. Thank you.
Thank you very much. Adams.
People who are going to be deciding this. No, that's fine the way it is. That's fine. May it please the court and gentlemen of the jury. The defendants, all sitting here, are charged with murder. If they are convicted, there is only one penalty: they will all be executed. Now, His Honor will tell you that if they fired in self-defense, then there's no crime at all, much less murder. And that's what this whole case is about. Now, I listened, as you did, very carefully to the King's attorney. And there were two words you did not hear him use. The first word you didn't hear him use was mob, M-O-B. You didn't hear that word. The second word you didn't hear from him is hundred. This was a mob of 100 people. And there were 9 soldiers, and they each had 1 shot. And that was it. And it was a mob of 100. And what did this mob of 100 have? Gentlemen of the jury, this mob of 100 had sticks, they had stones, they had snowballs that were as hard as ice. Now, let me go back to the beginning, because the facts leading up to the shooting, there's no contest about that. All the witnesses are saying the same thing. We have a boy who comes upon the private who is guarding the King's treasury, where all the money is. It's at night, and it's in the winter. And this little boy runs off and is crying. And all of a sudden, out of nowhere, a crowd comes, an angry crowd descends on this one soldier. And this crowd includes Negroes, it includes mulattoes, it includes Irish, it includes Jack Tars. This one soldier has got to be scared for his life. And he calls for reinforcements. And immediately a bell from the nearby church rings. Now, a church bell rings for 3 reasons, and we all know this, gentlemen of the jury. If there's a church service, if there's a holiday, or if there's a big fire. Well, there was no church service, there was no holiday, and there was no fire. It's obvious this was all planned in advance. And immediately there's 100 people surrounding 9 soldiers, and they're all, and what are they doing now? Don't take the testimony of our witnesses. Let me remind you of what William Wyatt said, whom the King's attorney himself called. I saw 100 people in the street huzzahing, crying fire, damn you fire. And then what do we hear? We hear from Ebenezer Bredgum, a good Boston citizen, who says a party of about 12 in number with sticks in their hands. It wasn't just having sticks in their hands. They stood in the middle of the street, gave 3 cheers, and immediately surrounded the soldiers and struck upon their guns with their sticks and passed in front of the soldiers toward Royal Exchange Lane, striking the soldiers' guns as they passed. Passed to go where? To go to where all the money is. And then we have the testimony of Richard Palms, who says, I saw something resembling snow or ice strike the grenadier on the captain's right. He instantly stepped 1 foot back and fired his gun. After the gun went off, I heard the word fire. I don't know who gave the word fire. Now, the King's attorney makes a big fuss about how the soldiers hated the townspeople and were just waiting for some excuse to fire. Now, I have no doubt that my clients hate the colonists. That's clear. But so what? It proves nothing. In the first place, the prosecutor hasn't proved who cried fire. There's all sorts of testimony all over the law on the subject. if you take the testimony of Mr. Wyatt, whom he called as a witness, remember, he says all the colonists, all the people in this mob were calling out, "Damn you, fire." And assume that my clients thought that Captain Preston called out fire, which is one possibility. Well, their commanding officer is telling them to fire. But the point is, the prosecutor has left this part of the case in complete doubt. The second thing is, hatred is a double-edged sword, gentlemen of the jury. Try to remember, the soldiers know that the townspeople also hate them, and therefore the soldiers have more reason to be afraid for their own lives. And the most important thing is that the soldiers clearly exercised the greatest restraint before taking any action. You've heard the deposition of Captain Preston on this subject, and I'm not going to repeat it. You obviously will remember it in the jury room, because I want to focus on the remarks, the evidence of Patrick Carr, who was one of the victims. And you'll notice the King's attorney didn't say a word about Patrick Carr. Patrick Carr, it's true, was Irish. And therefore, I understand if you feel you have to take his word with a grain of salt. But try to remember that Patrick Carr prayed to the same God that you, gentlemen of the jury, and I pray to. He is undoubtedly at this moment standing before the last judgment, as you and I will in the future stand before the last judgment. And I'm sure when he was dying, he didn't want to be worried about the last judgment, it being said, "Now, Mr. Carr, what do you have to say about the fact that the very last thing you said on your deathbed was a lie?" So let me tell you what his doctor said. Let me remind you. He told me he was a native of Ireland, that he had frequently seen mobs and soldiers called upon to quell them. He had seen soldiers often fire on the people in Ireland, but had never seen them bear half so much before they fired in his life. This is one of the 5 victims saying that. Now, you've heard from the state's attorney, and you're hearing from me, and I believe we have made an overwhelming case for self-defense. But let us suppose that you are in doubt when you go into the jury room. His Honor will tell you that the burden of proof not only is on the King's attorney, but he has to prove his case beyond a reasonable doubt. So even if you are in doubt about the case, we must prevail. I want to end my presentation with this thought. You and I are British citizens. You and I are second-class British citizens. We have grievances, you and I. We have been unfairly taxed. Some of my clients have been quartered in our homes against our wishes. I did not take this case because I like my clients. In fact, I do not like my clients. I took this case because I believe in the rule of law. There cannot be a civilization that's worth living in if it does not have a rule of law. And you cannot have a rule of law unless you apply the law in the same way to those you hate as well as to those you love. I have proven to you that this is a case of self-defense. You can prove to the world that America believes in the rule of law